Everyone, and welcome back to Hood Melon Culture Studios. We are now beginning part two of. Oh man, I have no idea how many parts video series is going to be until it's over. But I'm your host, Elohim the Yellow, and happy Easter. Praise my first host's second birthday. Hooray! Now let's go over this paper as it's Rare Breed against Thomas, and then a bunch of people who are also on there who should be the only people on there because Thomas Allen Graves is the inventor of all this technology. And whenever Edison was freaking suing freaking whoever the hell was freaking using one of Tesla's patents, freaking Tesla wasn't freaking in the lawsuit himself. So it's this whole lawsuit is kind of nonsensical, and he shouldn't even be in the lawsuit because his 772 patent relies on a rolling wheel attached to the locking bar and prevents the locking bar from ever making direct contact with the bolt carrier system or the reciprocation of the bolt to reset the trigger and put it back into battery to allow a subsequent shot to be fired. And I'll pull up some figures at the end of the video once we get through all these documents so that you can physically see why Rare Breed is full of. Now, if I make a lot of weird grunts and stuff like this, stuff like that during the video, it's because I am trying my darndest to prevent myself from cursing because this whole situation really pisses me off incredibly. So let's get to it. And this is the second time I'm going through and making this video because the first time, well, I was using an AI voice to basically just get rid of my lackings that I am freaking failing at right now, and and also to prevent me from cursing so much. So I'm going to try and do this whole thing without swearing once. So let's hopefully I can get through this, God willing. If I can't, well, F it. On this day, 15th day of December 2022, having granted plaintiff's second motion for default judgment against Thomas Allen Graves, and why did I just friggin' the AI voice was echoing over the video, so whenever it talked, it spoke twice of the same thing. It was getting like a lot of reverb or whatever the heck that is that you call it. So now I'm just gonna go through it and do it on my own because whenever you try and rely on crappy technological apps that are free on the freaking Play Store, nothing ever seems to go well. Now, I could use my freaking artificial intelligent virtual assistant to do all this for me, but that takes the fun out of it, and, well, I just thought of it, and well, I'm already here. So happy Easter, let's dive right into it. Sorry I'm so disorganized, I've had a stroke, and I am at my full-time job right now on my day off on Easter Sunday, covering for my coworker because his grandpa just died. And, well, I'm a very understanding fellow, and I love helping people out, even if they never return the favor, blah, 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 blah. On this 15th day of December 2022, having granted plaintiff's second motion for default judgment against Thomas Allen Graves, empowered by Graves Incorporated, the court hereby grants a default judgment in favor of plaintiffs Rare Breed Triggers LLC, a North Dakota limited liability company, and ABC IP LLC, a Delaware limited liability company, against defendants Thomas Allen Graves, powered by Graves Incorporated, an Oklahoma corporation in the following respects. Defendant Thomas Allen Graves and powered by Graves Incorporated have infringed Claim 4 of the U.S. Patent Number 10514-223 and shall be referred to as the 223 patent in the rest of the video just to save time. By making, using, selling, offering for sale, importing, and or promoting, providing, causing to be used without authority within the United States the Alamo 15 force reset trigger. This infringement was willful. Defendants Thomas Allen Graves and powered by Graves Incorporated are hereby permanently enjoined from infringement or contributing to the infringement of the 223 patent. Now, this is the magistrate who freaking is doing all this right now, handling the case. We don't know if he was dirty. We don't know if he was bought off by Rare Breed, but judging from how he completely and totally effed the pooch on this one, it's just, well, it's It's what is that? What are they? Sorry. Catchphrases, lines, thoughts, freaking all that stuff is much harder for me now post stroke. So bear with me, please. Um it's very negligent on his part. The magistrate, it's like Rare Breed was just like, hey, they did this to us. We promise we're not lying. And then the magistrate was, oh, well, as long as you promise you're not lying, I'll believe whatever you say. And then just handed the documents to the judge to sign. The judge signed them without ever having to read them because he thought his magistrate was actually doing his job, which he wasn't. And then the judge came back after signing two documents. Frickin', I think they were in favor of Rare Breed, or the first document was the judge dismissing Rare Breed from getting the claims or the asset claim hearing, and then the second document is this one where he's basically signing it saying Rare Breed, you can have what you want. But then freaking Thomas wrote the judge directly and told him what was going on, and if he had even had the time to look at the documents, to read over the case, see what was going on. And once the judge did, he immediately came back, kicked the magistrate off the case because the magistrate is obviously not doing his job and is just a horrible person. And almost freaking totally screwed over one of the greatest minds history has ever known, Thomas Allen Graves. And now everything's being played fairly in a court of law, so hopefully everything gets summed up and settled with Thomas between Rare Breed, and then the judge just favors in Thomas all the way, and then frickin' moves the case to a criminal court to prosecute everybody who frickin' effed Thomas over. They get prison time. Thomas gets hundreds of millions, if not billions of dollars from this, and we can move literally into a future of Star Wars technology because that's what Thomas is holding back. And I want my own Death Star. Thank you. So that being said, let's move on. Defendants Thomas Allen Gray's infringed claim for the U.S. patent for the infringement was willful. Defendants Thomas Allen Gray's and Powered by Graves Incorporated are hereby permanently enjoined. Okay. Plaintiffs have suffered actual damages, no they haven't, of $1,308,600 as represented in the declaration of the Cole Doc 52, a sum which is within a fair scope of the allegations in the complaint. Due to the willful nature of the infringement, plaintiffs are entitled to treble damages. That means times 3, I'm assuming. And the court therefore grants default judgment in favor of plaintiffs' Rare Breed Triggers, but it wasn't the court, it was just the magistrate, Dirty LLC and ABC IP LLC against defendants Thomas Allen Graves and Powered by Graves Incorporated in the sum of $3,925,800. Plaintiffs may seek an award of reasonable attorney fees pursuant to 35 U.S.C. 285 by filing a motion, brief, and affidavit as required by Local Civil Rule 54 through 2 on or before January 6, 2023. Entered at Tulsa, Oklahoma this 15th day of December 2022. Gregory V. Frizzle, or Y. Frizzle, yeah, that's Y. Frizzle, United States District Judge. All right, let's move on to the next one. The next one is called First Doc Tulsa File. And it's up there. Okay. And this is the long one, so bear with me. Filed December 18th, 2023. Mark C. McCarty, Clerk, U.S. District Court in the United States District Court for the Northern District of Oklahoma. Case number 422CV00107GKFJFJ. Plaintiffs, Rare Breed Triggers, Monsters, and defendants, Thomas Allen Graves, Heroes. Alrighty then, and everyone else underneath Thomas Allen Graves, well, you're not a hero, sorry. Might as well be a monster as well. Alrighty then. Emergency motion set aside. Defendant emergency moves the court to set aside the previously scheduled default judgment December 20, 2023. Assets hearing set to be heard in front of a court. Administrator and not Judge Frizzle at this time, the indemnified defendant demands, as is his right, a judge hear all and decide all matters of this case. The alleged defendant further moves the court to allow 90 days from January 10th, 2024 for defendant to obtain Premier Oklahoma Patent Infringement Litigation Counsel, followed by the court scheduling an evidentiary hearing in front of Judge Gregory Frizzle on the meritorious facts and evidence in this case, indisputable USPTO federal records, and the content of which shall prima facie the case evidence defendant's priority date filed U.S. Patent 9816772 and will be referred to as a 772 patent to save time, and defendant's superior rights to plaintiff's inferior copycat infringing U.S. Patent 223 right. For the reasons given, any asset discovery hearing in this matter would be premature and not in the interest of justice. Come now, the alleged defendant, and rebut the court's rebuttable presumption that the default judgment entry in this matter is viable as if based upon the merits. It is not. Moreover, having obtained by the infringers, plaintiffs, shall be made to prove up or go home in evidentiary proceedings before this bench. Nor is default in any way acceptable outcome to the alleged defendant, who in recorded fact scientifically pioneered his conceived, developed prototype, built and established all superior rights in this case. Emphasis added, default judgment is and was never acceptable to this contractually indemnified alleged defendant. Emphasis added. Note, defendant shall mount vigorous attack on the plaintiff's fraud upon this court. Defendant in evidentiary shall prevail on the merits, something the plaintiffs have yet faced in their lawsuit approach to covering up a crime spree, mass infringement of U.S. Patent number 772, Thomas Allen Graves rights. Ironically, the alleged defendant in this matter is wholly indemnified. Indemnification is inarguably, as it was given defendant licensor impartial consideration for consummated superior rights license grant to use the alleged defendant's established U.S. Patent 772. So, Thomas basically made a deal with BDU, or Anthony McKnight, freaking one of those egghead yahoos that freaking should be buried under a mountain of termites and salt. One of the conditions for him to license the patent out to them was that if anyone like Rare Breed freaking got their head so far up their keister and decided to try and sue Thomas for quote unquote infringing upon their patent or anything else like that, anyone for that matter freaking comes to Thomas with a lawsuit freaking involving anything that has to do with the licensed patent that he gave to BDU, freaking that they would have to represent him in a court of law, they would pay all the fees, and they agreed to it. That was part of the condition for him to license the technology for BDU to manufacture, make, sell, promote, yada, 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 which they never did. They breached the contract, the licensing agreement right from the get-go whenever, who was it from Wolf Tactics? See, all these company names, but they're all associated with each other. It's just crazy. So, yeah, because the Round brothers were freaking working with Thomas before they got involved with BDU, and then they stole everything. It's a mind F of a situation that took place, and it must have had so much preparation, like countless preparation, to be able to make it this far. And it's crazy how much of a criminal enterprise can flourish in this country and just totally try and destroy innocent good men like Thomas and almost get away with it. It's mind-boggling how any of this could even happen in the first place. I am shocked and ashamed and appalled, and it's just reading this after knowing all the facts and everything else, it is just incredibly mind-numbing. So bear with me. I'm sorry. Not sorry. Right. Ironically, the alleged defendant in this matter is wholly indemnified. Yep, read that. Ironically, both plaintiffs and defendants in this matter are infringers. Yep. Of this alleged individual defendant tag, controller and licensor of 772 rights. The alleged defendant filed for patent on September 11, 2014, thereby established his priority date superiority of his U.S. patent 772. Years later, in 2022, infringers in this matter gave defendant full indemnification and partial consideration for a license grant to use defendant's U.S. patent method technology 772. The defendant is the sole, several, and superior U.S. patent rights controller and licensor of USPTO patent number 772 and its claim 1. The defendant and his local counsel as controller and licensor did issued a license to use for in part from the licensee full indemnification for the grant of the license. Ironically, that 772 license on its face proves Janeway of Oklahoma is not an infringer of plaintiffs, unenforceable against U.S. Patent 772 licensees, U.S. Patent 223. See judgment order re when U.S. Patent 223 is found invalid or unenforceable, the judgment is automatically void. Nonetheless, in the end, Janeway entered into a mutual sweetheart secret deal to which each side stipulated the parties made final, and the court entered amended judgment for disclosed $24,000 in legal fees and disclosed infringement claim of $3.9 million, a trebled amount. The deal was sealed by the court. The infringers, being one in the same, both plaintiffs and defendants in this case, have maliciously named alleged defendant Thomas Allen Graves, Oklahoma scientist, pioneer technology, inventor, developer, and builder of the method technology before the bench, thereby reducing him to a fully indemnified alleged defendant. In the interest of justice and under doctrine of fairness, defendant having established control and holds the sole and several exclusive right to license the 772 superior rights. Defendant now hereby emergency moves this court for Judge Frizzle to hear all matters in this case and that he set aside or quash the plaintiff's request for December 20, 2023 scheduled asset hearing based solely upon a default, never heard on the merits, thus the scheduled hearing is premature. Plaintiff hopes to, by lawfare, abuse of process, and shenanigans, the December 20th, 2023 scheduled hearing, plaintiff hopes to execute a second theft of defendant's rights and IP assets under the default judgment. The plaintiffs, individuals as owners, executed a grand larceny theft of great value from defendant's lab June of 2016, and that's when they stole all of his prototypes, his paperwork, and everything else, and allowed them to create the 223 patent in the first place because, let's face it, these guys are not that smart. They know how to lie really well, but on a judgment solely based on intelligence, frickin' Lawrence, whatever the hell he is, frickin', sure, he's a grunt. You point, he shoots. That's pretty much all his experience right there. And everyone else, they're just con men. So, I mean, they're not that intelligent. They know how to steal, but stealing ain't that smart. So, I mean, if you were intelligent, you wouldn't have to steal to make your way in the world. Now, the defendant, September 11, 2014, priority date filed U.S. Patent 772 is superior to plaintiff's 223. Even cursory review provides the court evidence to plaintiffs. Johnny come lately, copycat, U.S. Patent 223. 223 is several hundred thousand patents late behind 772. Thus, 223 on its face is the inferior patent right. The defendant's right is superior, U.S. Patent 772. Such head-to-head priority date review would provide this court overwhelming cause to set aside, cancel. Let me zoom in a little bit. My eyes aren't what they used to be. Cancel, quash the December 20th, 2023 asset hearing until such time as an evidentiary hearing may be scheduled by Judge Frizzle, that evidentiary proceeding to be heard by Judge Frizzle in the interest of justice and under the doctrine of fairness. Defendant hereby formally requests an evidentiary hearing to be scheduled by Judge Frizzle for a time and date 90 days from January 10th, 2024 to afford the alleged defendant sufficient time to discern and obtain Oklahoma's premier patent litigation counsel for the evidentiary hearing and trial if need be. Come now, the alleged defendant Hereafter, the defendant. The defendant, Thomas Allen Graves, an Oklahoma native son, and the only party being a multi-published scientist in the entirety of parties in this matter. In this case, I am the inventor of the U.S. Patent 772, method and technology at U.S. Patent 772, Claim 1. Further, plaintiffs in this and other venues proclaim 772 in lawfare complaints is a purported infringer of plaintiffs' rights. The defendant in this case being the developer and prototypical fabricator and builder of a fully developed, functional, fully operational by 2013 FFT method technology by then in the form of completely new technological breakthrough G1 carbine, a small arms breakthrough in safety for America's armed forces. 3. Defendant creation being a complete 100% new method technology small arms system, emphasis added, pioneered by defendant and protected by U.S. Patent 772, method technology defined in Claim 1. As stated in plain language within U.S. Patent 772, hereafter, the 772 patent, the defendant's method technology was specifically conceived, pioneered, developed, and built for America's armed forces, not for plaintiffs. Grand larceny theft of it, June 2016, and habitual unauthorized use. Alright then. Plaintiffs did in grand larceny theft obtain defendant's fully functional physical prototype, accessing the defendant's lab and removing the prototype technology from defendant's presence lab in June of 2016, which really sucks because they stole a whole lot more than just the freaking trigger technology. They also stole a lot regarding the rocket technology and the Star Wars inertia engine technology, and it's just it's crazy. It's just crazy. And they stole a bunch of really cool freaking revolvers that had freaking FRTs in them, or ARTs, whatever you want to call it, the reset triggers, and they were amazing because they were extremely accurate, extremely powerful, and they shot faster than any ART that's currently on the market right now, and I would loved to get my hands on one of those amazingly beautiful, just when you see the gun, it is just one of them. It's like when you see old cars, you can tell there is soul in them and artistic value, and just you can tell someone really just bled into the creation and made it what it is. But nowadays, everything's just all blocky and ugly, and cars are made of plastic, and it's just disgusting. And freaking guns are kind of following the same way, unless you freaking get aftermarket parts to freaking customize them on your own. But this revolver was just beautiful. I would have loved to own one, and now I can't because these greedy a-holes robbed him, and now they're suing him to try and freaking put him into debt so badly that he won't even be able to feed himself or be able to freaking take the fight to them. And that's why I am trying to save up money, or I'm raising a fundraiser so that we can donate to Thomas Allen Graves, so that we can make sure he gets his, and everybody associated with Rare Breed, Anthony McKnight, BDU, all the infringers get taken down to the lowest depths of the circles of hell, and they'll never see the light of day ever again. Now, let's continue. Did in grand larceny theft obtain defendant's fully functional physical prototype, accessing the defendant's lab and removing prototype technology from defendant's presence lab in June 2016. Plaintiffs then 3 years, 4 days later, copycat filed September 15, 2017. Sorry, I woke up like at 5 a.m. today, and it's like 3 p.m. now, so sorry. In the matter of plaintiff's 223 patent, a plaintiff exhibit of this 223 in this case is claimed as the basis for plaintiff's fraud upon the court. Foul, or is that Fox? Fox or foul? I'm not French. Claims in the complaint are used to prop up and obfuscate plaintiff's abuse of process and open lawfare in lieu of merit, substance, or superior enforceable right in bringing in this frivolous case. Plaintiffs filed U.S. Patent 223 September 15, 2017, 3 years and 4 days after defendant's priority date. Superior U.S. Patent 772 was filed September 11, 2014. Plaintiffs filed 223 using the alleged defendant's stolen lab notes and physical prototype and 772's Claim 1, all of which are easily shown in evidentiary hearing to have been used to fabricate U.S. Patent 223. Because the wording they used for 223 is pretty much along the lines a straight up just pure plagiarism of the 772 patent at its core. Just like how Muslims plagiarize the Bible so that they could create their own paganistic religion. Haha! Alright, moving on. The lab notes and defendant's physical prototype plaintiffs had stolen by 2016. However, the alleged defendant, U.S. Patent 772 Claim 1, the plaintiff's Claim 1 was simply copied from, copied from defendant 772 Claim 1, stolen lab notes, stolen prototype, then filed by plaintiff September 15, 2017. The financial ability of plaintiffs to sustain relentless attacks in lawfare comes from plaintiffs having induced, manufactured, imported, given foreign nations, possessed, offered, and sold, and garnering $240 million. That's $240 million taken from this Oklahoma native son in plaintiff's unjust enrichment, emphasis added, unjust enrichment from stolen technology. Now, Thomas was going to give us the most spectacular world of all time with frickin' anything that can, I don't want to freaking get into too much detail, but like Star Wars fighters, X-Wings, Star Destroyers, frickin' the Trade Federation control ships, all that crap. Basically mega structures that would defy the law of physics to be able to frickin' fly. The amount of power that you would need to make something like that take off the ground would be just astounding. But he invented a freaking piece of technology or an engine that can do just that. So it's just, if none of this had happened, we would all be literally in the most If none of this had taken place, we'd be living in the golden age of technology right now. Literally, frickin' the coolest time to ever be alive. But because of the greed and wickedness inside the hearts of man, we have to frickin' be held back from advancement and progression yet again because people are evil. Just stop being evil already so we can live in the super advanced, magically scientific space world that Star Wars gave us. And Thomas made the technology possible, and I really want to live in that gosh dang world already, and I'm pissed off that I don't have flying whatever the heck I want, or a freaking castle in the sky, just all that. I'm angry. I am very angry. I want a flying boat so I can freaking cruise around the world and survey my planet because, sorry, I'm getting off topic. Sorry. I'm not editing any of this out. It allows you to get to know me better. Sorry. Alrighty then. The lab notes and defendant's physical prototype had stolen 26. However, the financial ability, $240 million. $240 million, oh my goodness. Yeah. Plaintiff's case is anything but novel. Plaintiffs, upon information and belief, have garnered from sales of plus or minus 500,000 infringing triggers sold at average $499.99 plus, each with published evidence screen captured of currently offered same for as high as $1,000 each. And yeah, so that's crazy. Oh yeah, if anybody wants a quick update on what's going on currently, a company called Performance Triggers just released extremely infringing device called the Artrius trigger, and it literally looks like a copy and pasted version of the Alamo 15. So they are definitely freaking 100% without a doubt infringing on Thomas's 772 patent. So, and they're just doing it willfully, freaking 100%. They don't care. They think Thomas is so far down in the dirt right now and he's never going to freaking see the light of day or get a freaking breath of air or rest ever again. Freaking that they're just able to go along and do whatever the hell they want. Well, performance triggers, you're going to get one hell of a nasty rude awakening. Uh-huh. All right, so yeah. Infringing triggers sold basically $500 plus and $1,000 each after freaking the ATF started rating people, and then everybody just upped the prices on the freaking triggers. Now, in the process, the plaintiffs have grossly violated defendants' copyright name, right to publicity, copyright, and infringing defendants' U.S. Patent 772 with plaintiffs' triggers, KA, FRT 15, etc. All plaintiffs have devastated alleged defendants' federally protected superior to 223 rights, priority date, upheld intellectual property, federally protected by U.S. Patent 772. Affidavit of fact. I, Thomas Allen Graves, hereby declares and states, under penalty of perjury, it is your affiant, not the plaintiffs, that conceptualized 772 method and technology, then pioneered, developed, fabricated each piece of the new novel small arm meant for America's armed forces. It is your affiant, not the plaintiffs, having then built this new small arm from loose individually crafted pieces into a completely innovative, wholly new method technology in semi-automatic small arms, a system meant to increase safety in and for America's armed forces. Your affiant's small arms safer system is meant to eliminate full auto live fire training accidents, combat panic trigger clinch driven uncontrolled emptying of full auto arm. I'm assuming he means spray and pray right here. Morbidly clinch of fire controls. Okay, spray and pray. Yeah, is the Army's way. Yeah. And yeah, freaking Larry, he wasn't in the Army, he was in the Navy, so we all know he's going to do fine in prison since he's had miles of pipe run through him being in the Navy and all, causing mortally wounded operators to fully discharge their full auto weapons, endangering fellow teammates, and whereas your affiant in fact accomplished new novel safety in small arms, then made it reality and without any sacrifice of needed rates of fire for armed forces. It is for these facts obvious why talentless opportunist plaintiffs needed to commit grand larceny theft June of 2016 from inside my lab in a take of your affiant's exclusive invention, method technology pioneered and fully developed and already protected 2 years by defendant's U.S. Patent 772 filed September 11, 2014. And whereas your affiant would believe the above facts make obvious the why plaintiffs have used in this case this method technology for their unjust enrichment, unjustly prospering from infringement violations of in part 35 U.S.C. 271 A, B, and C, counterfeiting affiant's name in advertisements and product offerings in violation of federal S18 U.S.C. subsection 2320 felony counterfeit branding, as well as violations of defendant's copyrights in violation of federal 17 U.S.C. subsequent sec 106 and 107, unauthorized use of copyright for personal gain in attempts and at times even fighting among themselves to make your affiant's exclusive method technology their own. And whereas this was accomplished by default judgment, such shall not be possible to accomplish in an evidentiary hearing on the facts, evidence, and merits. And whereas the plaintiffs are only afforded such abusive process by vast unjust enrichments by the plaintiffs, having realized from mass infringement of your affiant's rights and superior IP, the plaintiff hyper-litigious suing executed lawyers of facade, abusive process, and the appearance of judicial misprison. And it is for this reason set aside of the asset hearing scheduled for December 20th, 2023 without first an evidentiary hearing of the facts. It is premature. Set aside in this case is therefore both appropriate and imperative to ensure Judge Frizzle hears facts and truth both. by presiding over the evidentiary hearing whereby plaintiffs' legal shenanigans may be properly exposed, and wherein an evidentiary hearing at its conclusion is with your affiant's request for criminal referrals for the plaintiffs, and wherein the roles of parties in this case shall likely reverse as the facts and truth exposed plaintiffs are in fact the infringers, and in fact the defendants and the alleged defendants shall be shown in fact true the rightful plaintiffs. Purposeful infringement, torturous business interference and business interruption, losses, damages, punitive, everything inflicted upon all defendants in this matter. Affiant further saith not. Date December 18th, 2023. Thomas Allen Graves, 295 Eagle Point Lane, Sand Springs, Oklahoma, 7406-512-363-8440. Give him a call. He'll probably answer. Who knows? He might not. I don't know. Again, give him a text and be like, thanks for being the coolest inventor of modern time ever. Love you. Document notarized affidavit of the fact by Thomas Allen Graves, tagged December 18th, 2023, notary block seal. Thomas Allen Graves appeared before me with valid ID or is known to me on December 18th, 2023. I witnessed him sign his affidavit of fact. Notary public DeAngles, Michael DeAngles? Oh, D'Angelo. Okay. Yeah. D'Angelo Mitchell. Okay. Yeah, that's why I don't like friggin' the way people write around. Notary Public, State of Oklahoma, commission number 23012-961. My commission expires 09/25/2027. Thomas Allen Graves of Eagles Head Island, Oklahoma. Qualifications in the field of thermodynamic engine science and related technologies. All right, now let's go over all the experience Thomas has freaking underneath his belt. Experience of 1972 through 1975. Preliminary research and experimentation with various aspects of fluid and electromagnetic machine science, including the design and development of elementary engines, motors, electromagnetic machines, and hydraulic machines. 1975 through 1977. Design and development of multiple devices and machines, including positive displacement fluid jet pumps wherein a fluid is accelerated via reciprocating engine exhaust. Design and development of multiple solid fuel driven jet pump. Author of technical writings covering hydraulic and pneumatic systems. Experimentation with induced atmospheric lighting. Capture via trained conductors positioned with solid fuel rockets, etc., etc. 1977 through 1985. Design, development, and experimentation with magnetic piston motors, rotary magnet motors, electric motors, and generators, solid and liquid-fueled rocket engines. Wow, man, this guy's a literal rocket scientist. Tooling, test equipment, radio transmitter and receivers, etc., etc. 1985 through 1990. Design, development, and experimentation with electric and magnetic machinery, experience with electrical inverters, converters, transformers, and switchgear, continued design, development, and experimentation with reciprocating ICE and electrical magnetic motor and motor control systems. Experimentation with large-scale fluid gas oscillators. Sorry about all the freaking messages from my messenger. Someone's trying to buy like my entire freaking art collection, or 3 different entire art collections I've released over the past year for like way too much money for me to consider as an actual thing. So let me get through this and I'll get to that. Yeah, large scale fluid gas, etc., etc. Design, development, experimentation with electric magnetic machinery, experience with I already said that, 1990 through 2000. Design, development, and experimentation with hydrogen-based systems, including electrolyzers and hydrogen-based reciprocating ICEs, including liquid and solid piston-sealed volume electric-powered ICE, EPIC, 2-stroke, monostroke ICEs. Design, development of high-voltage machines, including rotary, electrical inverters, converters, generators, transformers, and transmission systems, and high-voltage capacitors, resistors, inductors. Design, development of piston supercharging and ICE operating with expansion and contraction of combustion products. Design, development of high-voltage, solid-state, electrical machinery, including wireless transmitter, receiver, and converter systems, author of multiple technical writings, etc., etc., 2000 to 2010. Design, development, and experimentation with advanced hydrogen-fueled ices. Advanced experimentation with piston supercharging hydrogen fuel systems, hydrogen ice controls, and etc., etc. Design, development, and experimentation with advanced thermodynamic engine operating systems, author of multiple technical writings related to advanced engine science and systems, including the architecture of energy consumption, detoxium, etc., etc., 2010 through 2019. Design, development, and experimentation with advanced inertial systems, including pendulum, gyro, and linear mass acceleration machinery. Experimentation with large-scale, high-powered mechanical oscillators and resonators. Experimentation with inertial drive and positioning systems. Design, development, and experimentation with large-scale rotary piston ice steam motors. Experimentation with advanced turbo machinery, including steam and gas turbines. Design, development, and experimentation with advanced firearms, munitions, and fire control systems. Design, development of advanced expansion rocket nozzle technologies, including sealed volume rocketry, condensing steam turbines, etc., etc. Author of multiple technical writings in various fields, including 3 U.S. utility patents in the field of advanced firearm technologies, and etc., etc. Skills. I'm proficient in all fundamental aspects of mechanical design, development, and experimentation, including conceptualization, drafting, fabrication, and documentation. Peers, project partners, and associates. Carlos Talamentes, inventor, Panthera Marine. Rex Butler, M.E., Crane Carrier Corporation. Ted Howe, Master Silversmith. David Weiser, M.E., Chatlift Controls. Dr. Ray Attiliano, IP Executive, University of Texas. Dr. Pliny Fisk, Environmental Professor, Center for Maximum Building Potential. Henry McCullough, owner and M&M Machine. Sandy Ulrich, owner, Ulrich Aviation. Stephen Rounds, co-owner, Wolf Tactical. Bleh. Adam Strickler, architect, Gamesa Technologies. William Bashim, R&D manager, Motorola. Rafiq Kaisi, designer, RK Concepts. Dr. John Zayek, inventor, Zayek Technologies. Steve Huntsman, president, LoveEarth.com. Thomas Terman, EE, Harturian Engineering. Dr. Mahran Aruyan, business professor, University of Texas. Everett Treat, M.E., general manager, Aero Engine. David Minatsikanyan, CEO, Unite Armenia. Oh man, he's pretty cool. John Land, VP, Redbird Flight Simulations. Gary Sherrill, co-owner, Tulsa Turbine. Dr. Robert Mays, EEOE, Amazing Technologies. Victor Franco, CEO, Ice Engine Works website. TexasRevolver.com. ThomasAllenGraves.com. Contacts, tag6767@gmail.com. 512-363-8440. Give Thomas a text and tell him you love him for being the coolest inventor ever to exist in the history of mankind. And here's the last document we're going to go over. Well, at least read. So, yeah. I'm actually pretty impressed that I've been able to do this without swearing. So, props on me. Normally, I'm just swearing up and down the Normally, I curse like a sailor, like Jesus Christ, Popeye the Sailor Man sailor. They murdered Jesus Christ for frickin' speaking. Well, I kind of got the same problem of language, so bear with me. Filed February 01, 2024. Motion and notice for leave to file third-party complaint. The defendant, Thomas Allen Graves, moves for leave the recognition of cross-complaint in this action in interest of justice and keep with the doctrine of fairness. 1 second, I got a yawn. Okay. The Doctrine of Fairness. Introduction. Defendant Thomas Allen Graves moves the court for leave to make Big Daddy Unlimited Incorporated and Anthony McKnight third-party defendants to this action to serve on them the summons and third-party complaints set forth in Exhibit A attached to this motion. The motion will be made on the grounds that Big Daddy Unlimited and Anthony McKnight are or may be liable to defendant for all or part of any judgment recovered by plaintiff against defendant, as more fully appears from the third-party complaint attached as Exhibit A by Thomas Allen Graves, this 31st day of January 2024. All right, so I'm going to pause the screen record and just answer that guy already. And I'm back. Sorry, some guy just made me an offer of $9,600,000 for like all the art I've made so far. And oh my God. So I'm just, I honestly think it's not real and that it's a scam. Like, who the hell would pay $9,600,000 for freaking pieces of art made by God himself? I mean, I've made everything on this planet. Like, you don't see someone freaking picking a rock up off the ground and being like, this rock is worth $10 billion. No, it's nonsense. It's freaking utter nonsense. So, little art thingy there to let me know when I need to snip this part out of the video. So, yeah, let's continue forward. Individually moves for court-ordered licensee defendant relief requiring licensee Anthony McKnight, Big Daddy Unlimited Incorporated, Florida DBA, powered by Graves Incorporated's full forth with compliance with 8.1 indemnification clause and licensee license 8.1 given in consideration for a limited use license for manufacture and sales of defendant Graves Starfire technology triggers. The subject matter before this court, license was issued by Thomas Allen Graves to licensees Anthony Michael McKnight and Big Daddy Unlimited Incorporated, unauthorized DBA, powered by Graves Incorporated of Oklahoma, Starfire Triggers licensees serendipitously, unauthorized name change to Alamo 15 Triggers. The court shall now take judicial notice of the fact that licensee is limited by licensees unauthorized unlicensed use of powered by Graves Incorporated is in violations of licensee's 8/12/24 license. The license clearly limits licensee BDU McKnight's use to that patent of patent 772's derivative work, United States Patent Application Number 353, only, U.S. Patent 353, Starfire Technology Triggers only. See now attached Secretary of State documents for sequence of formation and whom formed it. Powered by Graves Incorporated of Oklahoma in violation of license SOS records show Powered by Graves PBG Incorporated was formed by licensee Anthony Tony Michael McKnight. Introduction. On or about September of 2021, Thomas Graves, Omar Zumat, Anthony McKnight, president of Big Daddy Unlimited Incorporated, and other agents, executives, and employees at Big Daddy Unlimited engaged multiple conversations regarding the licensing, manufacture, marketing, and sale of firearm triggers pursuant to patent owned by Mr. Graves. In these initial conversations, Omar Zumat, Anthony McKnight, and BDU discussed compensating Mr. Graves in exchange for Mr. Graves licensing the use of the patent that would allow BDU to manufacture, market, and sell specific firearm triggers. On or about October 21, 2021, Thomas Graves and Anthony McKnight, as president of Big Daddy Unlimited Incorporated, executed a licensing agreement. This agreement stated that Thomas Graves would license a patent filed on July 4, 2021, with issuance pending. United States Patent Application Number 632183533, the patent 353 patent, to McKnight and BDU. BDU would market, manufacture, and sell firearm triggers pursuant to affirmationed patent license. The licensing agreement also stated terms of the effective length of time of the license, the amount of money and royalties to be paid to Thomas Graves in exchange for granting of the patent license to BDU. The licensing agreement further stated that BDU and Anthony McKnight would indemnify Mr. Graves against any claims or lawsuit brought by third parties related to this licensing of the affirmation patent. After execution of this licensing agreement, BDU and Anthony McKnight proceeded to incorporate in Oklahoma under the name of Powered by Graves, LLC, defendant. powered by Graves, LLC, and Anthony McKnight then proceeded to manufacture, market, and sell Alamo 15 triggers and/or Starfire triggers. On or about March 8, 2022, plaintiffs filed suit against defendant alleging that respondent infringed upon petitioner's firearm trigger mechanism patent, U.S. patent number 223, granted January 24, 2019, by way of respondent licensing the patent application number 353 filed January 4th, 2021, commonly referred to as Alamo 15 trigger and/or Starfire trigger, to Anthony McKnight and BDU in order to manufacture, market, and sell Alamo 15 Starfire triggers. On November 14, 2017, Thomas Allen Graves was awarded U.S. patent number 9816772, the 772 patent, which is an independent core patent for the automatic reset trigger methods. This patent made capable the world's first small arms system having integrated use of automatic reset trigger technology, or Graves FlexFire technology, methods, and apparatus. U.S. patent number 9816772, describes and defines core characteristics and features including lawfully protected methods and apparatus governing all existing commercial triggers that automatically reset. U.S. patent number 772 is the priority date defining core method technology patent in the industry of automatic reset triggers, forced reset triggers, frickin' wide open trigger, whatever you want to call them, this is it. U.S. patent number 9816772 is a small arm including a trigger that is automatically reset during gun bolt movement, and that trigger automatically unlocks in battery, making the trigger ready to fire a subsequent shot. All known automatic reset triggers use claim 1 of this affirmation patent, including patent number 223. The patent application number US 632183353, this US patent number 9816772 had a continuation with priority filing date on September 11, 2014. On January 24, 2019, the U.S. Patent Office granted U.S. Patent number 105-14223 to Jeffrey Cooper Rounds. This patent is subject to U.S. Patent number 9816772 and cannot function without the use of U.S. Patent number 9816772 technology. Furthermore, the technology for this patent was maliciously derived from technology taken from Thomas Allen Graves' lab. On January 24, 2019, the U.S. Patent Office granted U.S. Patent number 105-14223 to Jeffrey Cooper Rounds. This patent is subject to U.S. Patent number 9816772 and cannot function without the use of patent number 772 method technology. Emphasis added. Furthermore, the technology for this patent was maliciously derived from technology taken from Thomas Graves' lab. On July 4, 2021, Thomas Graves filed U.S. Patent application number 6321833. This patent is for the Starfire and Alamo 15 technology. This patent is also dependent on the core U.S. patent number 9816772 owned by Thomas Graves. U.S. patent number 9816772 is the patent for small arm including a trigger that is automatically reset during gun bolt movement and that trigger automatically unlocks in battery, making the trigger ready to fire a subsequent shot. U.S. patent number 105-14223 relies on this patent to function and cannot be enforced, exists independent of U.S. patent number 772. Furthermore, as U.S. patent application number 353 relies on the core method technology of U.S. patent number 772 and not the technology of U.S. patent number 223, U.S. patent application number 353 does not infringe on the U.S. patent number 223. U.S. patent application number 353 and U.S. patent number 223 are independent of each other as they both use the core technology of U.S. patent 772. However, U.S. patent number 223 does infringe on patent number 772. U.S. patent number 772 was pioneered, created, and built piece by piece in Buda, Texas lab in 2013 by and awarded to alleged defendant Thomas Allen Graves. And it is the sole and several current property controlled by alleged defendant Thomas Allen Graves, as further evidenced by U.S. Patent and Trademark Office file number 508300098. dated January 17, 2024, rescinding a falsified assignment of this patent, alleging it to be a license to Wolf Tactical LLC, and rescinded in accordance with well-settled law for lack of consideration. Therefore, alleged defendant Thomas Allen Graves did not infringe on U.S. Patent Number 223 by way of U.S. Patent Application 632-18353, a derivative work under 772, emphasis added, as are the resulting marketing, manufacture, and sales protected under Graves 772 as a derivative work of 772. However, plaintiff did infringe on defendant's patent as a result of U.S. Patent 105.141.223, infringing upon U.S. Patent Number 772, created and owned by Thomas Allen Graves. Demand for relief in the interest of justice and fairness doctrine. Wherefore, plaintiff respectfully requests this court declare that plaintiff's Rare Breed Triggers LLC, ABC, IP LLC, and plaintiff's Hidden True owners, Michael and Angela Register and Cole Lelou of Spikes Tactical LLC of Florida, have exceeded their authority under color of law, have engaged in abusive process, frivolous lawfare, and fraud upon the court, and grant the injunctive relief sought herein. Bench imposed meaningful severe sanctions meant to chill plaintiffs' fraud upon the court as penalty to case, to include but not limited to severe meaningful monetary sanctions as well as severe sanctions to plaintiffs standing in the court, sanctions to plaintiffs' case for plaintiffs' malicious shenanigans exposed to the bench in this case by defendant. Defendant seeks further court-ordered licensee be made to comply with personal and corporate guarantees given defendant licensor Graves as partial consideration for the license at Clause 8.1 of license, in which licensees guarantees full indemnification of Thomas Allen Graves, which they never did, at License 8.1 Indemnification License Clause 8.1 Indemnification. Names of plaintiffs' Rare Breed Triggers LLC ETAL Graves is to be by licensee indemnification protected. Defendant to defend himself and his core priority date rights from infringers RBT LLC ETAL seeks this court's further ordered licensee timely funding in this case by licensee forthwith transfer of $300,000 USD to Thomas Allen Graves, enabling the defendant licensor counsel of choice, the Quinn Law Group. Licensees McKnight and BDU, DB doing business as Powered by Graves Incorporated of Oklahoma, have ignored the Rare Breed Trigger LLC complaint filed in March 8, 2022. This matter causing Graves a default judgment, licensees ignoring to date both personal and corporate guarantees, 8.1 indemnification obligations to Graves in this matter of the Starfire license before this court. It is obvious at this time only ordered relief shall ensure licensee compliance and Graves' ability to retain counsel of choice. The relief order sought in the amount of $300,000 United States dollar, $300,000 being Quinn's requisite retainer to be billed against during prosecution of 1422 CV00107 case. Defendant needs a Quinn Law Group takeover and prosecution to the fullest extent against the abusive plaintiffs and their case before this court, to include well-funded Quinn prosecution of defendant counterclaims for Rare Breed Trigger LLC ETLL ABCDEFG, infringement of Graves discovered by government entities based upon information and belief RBT LBC AG engaged in before this action, roughly $240 million. Plaintiff infringement and violations of 35 U.S.C. 271 A, B, and C of Graves' superior U.S. patent rights. Defendant relief sought in the form of sanctions and orders is made possible in part by licensee's license at its Clause 8.1 indemnification, wherein licensee doing business as Powered by Graves, etc. Formed by Anthony, it was formed by freaking Anthony McKnight, BDU, defendants, yep. Motion and notice for leave to file third-party complaint. Thomas Allen Graves respectfully moves the court for leave to file a third-party complaint. On or about September of 2021, Thomas Graves, Omar Zumat, Anthony McKnight, president of Big Daddy Limited Incorporated, and other agents, executives, and employees at Big Daddy Limited Incorporated, BDU, engaged multiple conversations regarding the licensing, manufacture, marketing, and sale of firearm triggers pursuant to patent owned by Mr. Graves, as a 772 patent. In these initial conversations, Omar Zumat, Anthony McKnight, and BDU discussed compensating Mr. Graves in exchange for Mr. Graves licensing the use of the patent that would allow BDU to manufacture, market, sell specific firearm triggers. On or about October 2021, Anthony McKnight and Omar Zumat traveled to Tulsa, Oklahoma to meet with Thomas Graves and further discuss the licensing, marketing, manufacture, and sale of firearm triggers. On or about October 2021, Anthony McKnight, Omar Zumat, another to be decided unnamed individual claiming to be an employee of BDU, Thomas Graves, and Mr. Graves' counsel met at the Brook Restaurant in downtown Tulsa, Oklahoma to discuss the terms of Mr. Graves licensing his firearm trigger patent to BDU in order for BDU to market, manufacture, sell specific triggers. Anthony McKnight and Omar Zumat assured Mr. Graves that if he licensed one of his firearm trigger patents to BDU, that BDU would market, manufacture, and sell firearm triggers related to the aforementioned patent. Michael McKnight and Omar Zumat also stated that they would compensate Mr. Graves in exchange for this patent license in favor of BDU. Furthermore, Mr. McKnight, we're going to start calling him Mr. McNuggets from now on, Mr. McNuggets and Omar Zumat stated that BDU would procure and pay for all his legal representation and fees in the event he was sued by any third party or any government entity. This is evidenced by Section 8.1 of the patent agreement between Thomas Graves and Big Daddy Unlimited and Tony McKnight licensee, Tony McNuggets, which states that Tony McNuggets and BDU and their heir successors assigns legal representatives for liability incurred to persons who are injured as consequence of the use of any invention manufactured by the licensee or as a consequence of any defects in the invention, and to provide legal representation for all patent claims and any third-party claims related to this agreement. Furthermore, licensees shall indemnify licensor and his heir successors, assigns, and legal representatives any and all claims, suits, or liabilities brought any third party, including but not limited to Rare Breed and the ATF, as a result of this patent license agreement. On or about October 21st, 2021, Thomas Graves and Anthony McKnight, as president of Big Daddy Unlimited Incorporated, executed a licensing agreement. This agreement stated that Thomas Allen Graves would license a patent filed on July 4th, 2021 with issuance pending United States Patent Application Number 632183353 to McNuggets and BDU would market, manufacture, and sell firearm triggers pursuant to aforementioned patent license. The licensing agreement also stated terms of the effective length of time of the license, the amount of monies and royalties to be paid to Thomas Allen Graves in exchange for the granting of the patent license to BDU. The licensing agreement further stated that BDU and Anthony Michael McNuggets would indemnify plaintiffs improperly made a defendant in this case licensor Graves against any claims or lawsuit brought by third parties related to this licensing of the aforementioned patent. After the execution of this agreement, Big Daddy Unlimited Incorporated, Tony Anthony Michael McNuggets, by the way of Powered by Graves, manufactured, marketed, and sold Starfire and or Alamo 15 triggers by way of license of United States Patent Application Number 632183353, the 353 patent, from Thomas Graves. After the execution of the aforementioned licensing agreement between Thomas Allen Graves and BDU, Graves was sued by third parties. Upon learning of the first lawsuit against Tag/Graves, Graves contacted BDU and Anthony Michael McNuggets and informed them of the lawsuit. McNuggets personally and for BDU stated that they were familiar with the lawsuit and would be engaging and paying for counsel to represent T.A.G. Graves in this lawsuit. Several days passed and BDU failed to obtain counsel for Mr. Graves. Mr. Graves continued to contact BDU by phone, email, text, etc. to inquire about BDU hiring counsel and legal representation for Mr. Graves regarding the affirmation lawsuit against him. During these conversations, BDU, Tony McNuggets, and the representatives of BDU continued to assure Mr. Graves that they were taking care of the affirmation lawsuit and his hired counsel to represent Mr. Graves in his lawsuit. BDU never hired counsel to represent Mr. Graves in this first lawsuit against him by a third party, and to date, BDU has never procured counsel to represent Mr. Graves for any claim or suit against him brought by a third party as a result of the licensing agreement. Request for relief. Wherefore, defendant respectfully requests this honorable court declare that defendant Tony McNuggets and Big Daddy Unlimited Incorporated have breached the patent license agreement between Big Daddy Unlimited Incorporated and Thomas Allen Graves, and grant the equitable relief sought herein, as well as any other relief available in equity or at law, including but not limited to monetary compensation. The injunctive relief sought includes but is not limited to a court order. Defendant Tony McNuggets and Big Daddy Unlimited furnishing payment to Thomas Allen Graves in the amount of $300,000 in order to retain his choice of counsel, the Quinn Law Group, to bill legal fees against, necessary to litigate the current lawsuit that was initiated by plaintiff as a direct result of the actions taken by Tony McNuggets and Big Daddy Unlimited. Respectfully submitted, Thomas Allen Graves. Thomas Allen Graves, pro se. Pro se means he's doing this all on his own. No lawyers in the courtroom, just him defending himself against multi-million-dollar dogs and a freaking judge. So, yeah, when you go in that courtroom all by yourself, you can talk yourself up in the mirror all you want, but the second you get before that judge, you might get stage fright, you might get whatever the hell. Friggin' up against those multi-million-dollar freaking lawyers and all that other nonsense, oh my goodness. I'd be shaking in my boots if I wasn't who I was, and I'm glad Thomas is a freaking very strong and powerfully good man. Intelligent, smart, friggin' courageous, freaking determined to not let these freaking animals take his entire life's work from him and just shove him into the dirt afterwards. Now, following locations or offices of counsel for McNuggets, Big Daddy Unlimited: Anthony Michael McNuggets, Blackstock Incorporated. Offices of McNugget and BDU, Big Daddy Unlimited Incorporated, 7600 Northwest 5th Place, Gainesville, Florida, 32607. Give them a call, write them a letter, tell them they're terrible people. I don't care what you do, it's a free country, but just do something. These monsters need to be stopped. Stephen Kalishman, personal counsel, McNugget and BDU, the Powell Building, Hale Village, or is that Halley or Hale? Village Center, 5055 Southwest 91st Street Terrace, Gainesville, Florida, 32068. Tom Glover, Northwest Registered Agent, LLC, CNC Holdings Group, LLC, 7901 4th Street North, STE. What does STE stand for? I don't know. 300. St. Pittsburgh, Florida, 33702. Jose I. or L. Moreno, personal counsel, 240 Northwest 76th Drive, Gainesville, Florida, 32607. Robert L. Ratet, personal counsel, Davidoff, Hutcher and Citron LLP, 605 3rd Avenue, New York, New York, 10158. Motion and notice for leave to file third-party complaint. The defendant, Thomas Allen Graves, moves for leave and recognition of cross-complaint in this action in the interest of justice and keep with the doctrine of fairness. Introduction. Defendant Thomas Allen Graves moves the court for leave to make Big Daddy Unlimited and Anthony McNuggets third-party defendants to this action and to serve on them the summons and third-party complaint set forth in Exhibit A attached to this motion. This motion will be made on the grounds that Big Daddy Unlimited and Anthony McNuggets are or may be liable to defendant for all or part of any judgment recovered by plaintiff against defendant, as more fully appears from third-party complaint attached as Exhibit A by Thomas Allen Graves, this 31st day of January 2024, Thomas Allen Graves. It is so ordered, leave to file, third-party complaint is granted. Article 3, Judge Gregory Kevin Frizzle. I thought his middle name started with a Y. Why did he sign it? Oh, man, that's weird. Okay. Kevin. I'm sorry, I knew this guy named Kevin once, and we used to call him Slow Kevin. He was like a plumber's helper that worked with us. We were all plumber's helpers at the time, but Kevin was, he once tried to drain a water heater with the water still turned on to the water heater. And he was like, man, I've been draining this water heater for 3.5 hours and it just keeps on going. And we look at him and we look at the freaking ball valve going from the water in to the water out, and we were saying, why is that ball valve on? Are you freaking? He was like, oh my God, I can't believe I left the ball valve on. So from that day forward, we called him Slow Kevin. And from 321 Penguins, that show made by the people who made VeggieTales, Rick and Kevin. Not trying to make fun of the judge at all. It's just a funny name for me. All right. That's everything for reading over the documents. And I'm going to put together the rest of the pictures and arguments so that you can see why the 223 patent can never, why the 772 patent can never infringe upon the 223 patent, and why the 223 patent infringes upon the 772 patent. All right, so I've already made those videos. I had to remake this video because the freaking original video I made's audio was corrupted. So I hope this gives enough detail to everyone, and I hope I made it through this freaking video without cursing. And I hope I can edit out the F-bomb that I did drop. All right, I love you all. Have a great Easter Sunday. Praise the Lord, and peace. Then we're going to conclude that for part 2, just because I still have 1, 2, 3, 4, 5, 6, 7 documents to go over, and then y'all will be fully up to date. I did say I was going to give you all some clip examples of why the 772 patent cannot actually infringe upon the 223 patent, and I'll do that right now. 1 second. Basically, their claim is that the Alamo 15 or the Para 15 or the FRT 15, whatever you want to call whatever they're trying to say is infringing upon. All right, so this is the locking bar highlighted in green, which makes contact with the, the bolt carrier, and in reciprocation of the bolt itself, again, resets the trigger. Now, again, the locking bar makes contact right here on Rare Breed's 223 quote-unquote patent, even though their patent is null and void because it's an infringement just by existing. But again, this is the locking bar, that little part highlighted in green. It makes contact directly. Now, again, for the Alamo 15 to be infringing upon this patent, the Alamo 15 trigger's locking bar would have to make frickin' contact with this bolt system. Now, I'll show you why it's impossible for it to infringe on its patent. It's impossible to infringe because you see this big old frickin' red arrow right here pointing to this ginormous wheel right here, which is, you can see, is pinned in to the locking bar itself. Now, we can understand that this wheel attaches itself to the locking bar, but is distinctively separate from the locking bar itself. Look, there's the locking bar. There's the wheel. It is literally impossible for the locking bar to make contact with the bolt carrier system or the reciprocation of the bolt. All right, what is that? Case 2-22-CV-001707. Plaintiff's claim infringement of its claim for U.S. Patent 10514-223, the 223 patent. The four corners of this case are governed by the law of physics, which the wheel or roller interrupts the possibility of claim for infringement surfaces from ever making contact. Yet, that part is true. Yep. Here it is again. Again, see that big red circle right there with that bigger red arrow pointing to it? And then that other line drawn down with the 2 above it? Yeah. The big circle recognizes that that is the roller, again, attached to the locking bar. And number 2 shows you that is the locking bar, the part in which they are saying infringes upon the 223 patent. But to infringe upon the 223 patent itself, the locking bar showed on the frickin' drawn in red figure 2 would have to make direct contact with the bolt carrier system or the reciprocation of the bolt to reset the trigger. But it does not make any contact whatsoever. And the only thing that does make contact is the roller. So now that you know that Rare Breed is full of then hopefully everyone can stop frickin' saying Rare Breed stole it fair and square and all these other extremely effed up things to Thomas, who has been put through hell and back again, has his name, livelihood, family, everything dragged through the dirt and the mud, all so that y'all can freaking get some triggers that allow you to go pew pew a little faster. It's sickening, it's wrong, it's horrid, and it's disgusting, and I'm ashamed of every and each one of you. This is a dead bang winner for plaintiffs. Image _ 8824, the subject matter para 15 trigger provides judicial notice. All plaintiffs and its counsels either did know or should have known prior to complaint whether actual cause existed to file in the NDOC, I think that's the North District, Oklahoma Court case 422 CV 00021. In this case, actual cause exists for alleged trigger infringement of plaintiff's U.S. patent number 10514223 claim 4. As substantive, how do you say that word? Substantive. Is it substantive or let's substantive fact. I've never heard that word before ever. I don't know if it's supposed to be something else or if I'm just dumb, but I've had a stroke, so I might have forgotten it. Sorry. Both surfaces claimed for specifies shall make contact for an infringement. Do not make contact using the trigger because there is no wheel to interrupt the two surfaces from making contact, as in sister case 422 CV 00107. All right, yeah, that's basically just what I went over. I got these were sent to me by Gene, a really cool, awesome guy who is helping Thomas defend himself pro se in court, since you bastards over at BDU have completely and utterly ignored your obligation to defend Thomas from any and all amount of persecution by anyone since you were licensed, and that was a license agreement. Since you have breached that, I'm pretty sure he can sue y'all into the next 10 lifetimes. That's what I would give. That's what I would give Thomas, Rick, and if I was still ruling this planet as thoroughly as I'd like to. But Regan, when y'all die, I'll make sure y'all respawn as something horrible. How about that? As a matter of law, notwithstanding judicial canon 222.2a, in this case, a fair and impartial bench shall decide this in favor of plaintiffs. The case is a dead-bang loser for plaintiffs. Image 8822, the subject matter Alamo 15 trigger provides judicial notice. All plaintiffs and its counsels either did know or should have known prior to complaint whether actual cause existed to file in the North District, Oklahoma Court case 422 CV 00107. In this case, actual cause does not exist for alleged trigger infringement of plaintiff's U.S. patent number 223 claim 4. In this case, both services claim 4 specify shall make contact for an infringement. Do not make contact when using this trigger because the Alamo 15 wheel interrupts any contact. By the law of physics, the two surfaces required for infringement shall never make contact. It is literally impossible for them to make contact. Like here, we'll zoom in again. Here's the wheel. I'm sorry I got to say it like that, but since Rare Breed even filed this case to begin with, they might be a few blocks short of a what do you call those? Again, those alphabet number blocks you give your children whenever you want them to learn numbers, like subliminally or whatever, when they're not smart enough to actually comprehend language or mathematics or anything like that. You just give it to them, so it'll be like, subtly freaking downloading into their minds without them realizing it, etc., etc. But yeah, there's the wheel. There you go. You see the wheel right there. And then there's the locking bar that the wheel is attached to. And the wheel never makes it makes contact with the bolt carrier system, but it prevents the locking bar from making contact with the bolt carrier system and the reciprocation of the bolt. So yeah, I'm sorry I had to say it like that, but since these guys seem to be trying to live on their last brain cell and shouldn't have filed this case in the first place, I just had to be that kind of a-hole just for a moment. Sorry, forgive me, but not sorry, because y'all don't have to forgive me for Jack Diddley because I own your souls. All right, carrying on. That's everything for today's video. Happy Easter, everyone. It's my first host's second birthday today. And, well, I hope everyone has a great Sunday. Praise God, praise Jesus, praise Yahweh, praise Elohim, green, the Holy Spirit, praise Elohim, blue, the Father, and praise Elohim, yellow, me. Now, yeah, so I've been your host, and I hope you enjoyed this informative, educational video. And I'll get back to y'all on part 3, which is going to cover let's see what my notes say, the second Tulsa Graves claim charts, and then set aside default mail tag, and then the second Tulsa exhibit cease and desist. And depending on how long the documents are, I might just wrap up the rest of the documents in the same video. I might use the robotic voice app again, just to prevent me from cursing so much after reading total nonsense BS put out by Rare Breed and all the stuff they've done to Graves, just because it personally offends me to an extreme amount. And I'm very emotional, so I mean, but I'm a peaceful person. I got self-discipline, all that other jazz. You can tell it's really hard for me to not curse. And well, yeah. So don't worry about me. But yeah. So blah, 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 blah. Sorry, I lost my train of thought. Having a stroke at 27 due to frickin', what did the doctors say? Extreme emotional distress. Whenever I found out my ex-fiance was cheating on me. So, I mean, that's neither here nor there, but at least now you understand a little bit of what's wrong with me now currently. And just so you know, I told everybody I was God long before I had a stroke or anything happened to me. So you can't use that as an excuse to why you think I'm crazy. But in this country, you're not allowed to judge me if I call myself God, because it falls under the religious freedoms or whatever. And yeah, so you're not allowed to call me crazy either, or make fun of me, or I could sue you for, what is that? Discrimination. Ha ha!